Morning.
Good morning.
Thank you for dressing appropriately for court. So let me see. All right, so discovery, was that completed?
Yes, Your Honor.
All right, and today is the plea deadline date. So is this going to be a jury trial or have you all reached an agreement?
We have reached an agreement, Judge. There's one caveat that I should explain to the court.
Yes.
We're in agreement with all the terms. It's been a written plea agreement. We've
Mhm.
gone over it with Mr. Lunsford. We do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front.
Mhm.
Welcome to Judge Point, where we cover real courtroom drama. Today's case, State versus Mark Lunsford, charged with first-degree felony money laundering. The judge opens with formalities, then shifts to discovery and deadlines. Lawyers confirm discovery is complete, setting up a crucial plea decision. This isn't just about money, it's restitution, punishment, and second chances. Subscribe for more case breakdowns.
The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentencing.
The plea deadline arrives. Both sides agree, but the state demands restitution up front before sentencing. The defense asks for more time to confirm recipients and amounts. Nearly $300,000 is at stake. The judge proposes a compromise. Take the plea now. Allow 30 days for restitution and set sentencing later. A delicate balance is struck. Progress in the case while ensuring victims receive what they're owed.
And then if there is an objection to the restitution, if there's an issue with the restitution, we can handle it then.
Part of the people argument is that it would be paid up front. So as long as before sentence is imposed,
Yes.
then that'd be acceptable to the state.
All right.
Yes.
So then that way, once I'll take the plea today, the sentencing would not occur today. And I'm assuming there's no need for a PSI or TAP evaluation, or is there a need for that?
I think there is, Judge, because some of the terms and conditions, there are going to be things left up to the court's discretion. And
all right. Well, what I can tell you is, sorry to interrupt, but what I can tell you is
the judge sets the plan. Plea today, sentencing later once restitution is finalized. A restitution hearing will be held beforehand if disputes arise. Both sides agree, keeping the case on track. But the judge raises another factor, a PSI and TAP evaluation. These detailed investigations could heavily influence sentencing and add weeks of delay, pushing the case deeper into process and uncertainty.
just to cut through things. A PSI is going to take 8 to 12 weeks. So we can enter the plea today, and then it'll be 8 to 12 weeks. That'll give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right, so if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation, because that will give you more time with a PSI and TAP.
Yes.
The judge explains, a PSI alone takes 8 to 12 weeks, longer than restitution. Still, both sides agree it's necessary, allowing time for restitution and probation to investigate Lunsford's background. October 20th is set as the key date. The judge stresses PSI and TAP are separate, and both must be attended. It's procedural, but it shapes everything ahead: restitution, sentencing, and the defendant's future.
And what I can tell you is PSI and TAP, those are two completely different things. So they're going to be two completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's going to go. If we're a couple of weeks out, that looks hard, then I'll.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it out.
Thank you,
All
Judge.
right. Thank you. Lunsford, please.
With scheduling done, the case is called State versus Mark Lunsford, cause number 2, 1025, CR 1023. Lawyers announce and Lunsford confirms identity. The judge carefully reviews discovery, indictments, and rights. One by one, documents are read, signed, and confirmed. It sounds repetitive, but in felony pleas, there can be no mistakes. Every word ensures consent is knowing, voluntary, and on the record.
All right, court is going on the record. Court is calling 2025 CR 1023, State versus Mark Lunsford. Can I have parties announce?
Austin Stout for the state.
Sam Cogdill and Sam Locke from the Schmucks.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your
Did you review the true bill of indictment with your attorney?
Honor. Yes, Your Honor.
The state dismisses counts 2 through 55, proceeding only on count 1, money laundering exceeding $300,000. For Lunsford, the stakes remain steep. The judge outlines punishment, 5 to 99 years, or life, with up to $10,000 in fines. The courtroom grows tense. The defendant nods, understanding the risks. Each legal word narrows his options, shaping a future with limited exits.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections?
No, ma'am.
Mr. Lunsford, did you review the document entitled, just one moment.
The judge reminds Lunsford of his rights, jury trial, cross-examining witnesses, remaining silent. Entering a plea waives them all. He confirms understanding. A warning follows. If deferred adjudication is later revoked, he could face life in prison. The defense confirms Lunsford is competent and sane. Step by step, the record builds a wall of accountability, leaving no room for later appeal.
Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
The judge asks, was Lunsford threatened, coerced, or promised anything? Number, is he satisfied with his lawyer? Yes. Another warning. Non-citizens who plead risk deportation or denial of re-entry. Each confirmation tightens the legal knot. This isn't mere paperwork. It protects the plea from appeal. For Lunsford, every answer closes doors, binding his future to the record being built.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with it, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him?
The plea terms unfold. 10 years, a $10,000 fine, and $297,276 restitution. The state rejects deferred adjudication but recommends probation, 10 years of supervision. Added conditions include 200 community service hours, up to 60 days in jail, mandatory courses, and no contact with complainants. Lunsford confirms understanding. To the court, this balances guilt, restitution, and rehabilitation. For him, survival.
There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Council, could you all check the box here and
Yes, sir.
initial? Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation.
When asked for his plea, Lunsford says, no contest. The state submits Exhibit 1, evidence and financial records. The charge, laundering over $300,000. A minor math symbol error sparks clarification, showing how precise the law must be. The record stands, evidence in, stipulations accepted, objections waived. What seems procedural is actually the foundation of due process and justice in motion.
Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yeah, ma'am, you just. as I
Sorry.
said, they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
The court double checks. Did Lunsford sign stipulations voluntarily? Yes. The judge stresses the impact. Evidence enters without live testimony, and witness confrontation rights are waived. It's faster, simpler, but binding. Exhibit 1 is accepted into evidence. Each small step matters. The plea must be voluntary, informed, and sound, ensuring no cracks form for appeals to exploit later.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count 1, how do you plead? Guilty, not guilty, or no contest?
The court reviews exhibits. A postage stamp covers part of the evidence, drawing laughs. Still, the judge must check the math carefully, every figure tied to $300,000 in alleged laundering. Behind the humor lies serious weight, confirming proof of guilt. The courtroom waits as the judge calculates. For Lunsford, each number isn't just math, it's the measure of his freedom.
I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first-degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
After review, the judge finds sufficient evidence of guilt, but because Lunsford applied for deferred adjudication, the finding is delayed. Sentencing is set for October 20th. That day will decide everything: restitution, PSI results, and conditions. For now, Lunsford leaves court unconvicted but bound. His fate hangs between probation and prison, with the balance in the judge's hands.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
As the hearing closes, the judge gives strict instructions. Sign reset forms, meet probation, and prepare. The stakes are high. community supervision, restitution, compliance. With nearly $300,000 at issue, this isn't an ordinary plea. For Lunsford, it's a test of accountability and rehabilitation. October 20th looms, carrying the weight of freedom versus prison. The courtroom adjourns, but tension remains.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record? All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you.
Thank you.
The hearing ends with a reminder. October 20th decides everything. Restitution, probation, sentencing. Lunsford leaves under supervision, bound by warnings and agreements. His crime was financial, but the punishment stretches further. Justice now weighs restitution against second chances. For him, compliance is survival. Failure risks years in prison. If this case gripped you, like and subscribe for more real courtroom stories.